And we will, like she said, leave time for questions at the end. I'm not sure. The clicker was working before, but not working now. So we'll see if we can use the other arrows, yeah. So write down your questions on that card. I'm always glad to answer as many questions as I can. If it's a question that I think is going to take a lot of explanation or is very specific to your situation, I may tell you to go talk to the girl at my table. We can get your name and number and schedule you like for a personal consultation. So yes. So Kara Gibbons, you may have met her here before. So she's an attorney that works with me. And then Casey Bryan is also with us today, and Casey is our client coordinator. So she'd be glad to get your information. Like I said, if you have a question or concern that would take too much time to discuss today with everyone here, or it may be something personal that you don't want to bring up to the group. All right, so with that, we'll get started. Here's an overview of what we're going to talk about today. I'm going to give you just an overview of what estate planning is. I'm going to go through the different documents that our office includes as part of an estate plan. There are a lot of the documents you may have heard of before, so we'll discuss those. We'll go through some common estate planning myths and also go through a few of the frequent questions that we get and a couple of mistakes that you need to try and avoid in the estate planning context. So what is estate planning? So estate planning is really just creating a plan for what happens to you personally, your money and your belongings during your incapacity and also after your death. So a lot of times when people think about estate planning, they're focused on what happens to my stuff when I die. But really, estate planning also has that other component of what would happen to you if you weren't able to make your own decisions or manage your own finances. So it's a really important part of estate planning to make sure that you're going to be cared for during your lifetime, and then also, what happens to your assets at your death. I should also say that we left a folder with some information on each of the places, and we did include a list of some common estate planning terms in that packet. So if there are things that I say and you're not sure what that means, you might look on that list and see if we've defined it on there. If not, let me know and we'll add it to the list. So we want to make sure that everybody understands everything that we talk about today. So why does estate planning matter? Well, I think all of you probably have an idea that estate planning matters, or you wouldn't have come today to hear about this. But some of the reasons that I think estate planning is important is, one, it's going to document your wishes. So I get calls sometimes from family members who will tell me, well, I know my mom wanted me to have that car. And I will ask, what do the documents say? Okay, mom is gone now, which she can't tell us that that's what she wanted. The only way we're going to be able to know is if that's documented in a legal document. We had one person call our office one time and said, well, my dad left a will. So we said, okay, well, can you send us that will? Well, it's a note on my iPhone. So it's in the notes on the iPhone. Well, that's not a will. So it has to be a legal document that documents those wishes. So if those wishes aren't documented, if it's just a verbal wish, it's not going to be upheld. So you want to make sure that anything that you want has got to be documented. Having an estate plan is going to save time and money and will avoid court costs and delays. So that we'll talk about that a little bit as we go forward. Having estate planning can help avoid family conflict. So it provides clarity. If you're clear about what you want in your plan, your family's more likely to honor that because they know that's what you wanted and you were intentional about it. And most importantly, it's going to provide you with peace of mind. So once you get your estate plan in place, you should feel good about it. And if you don't, then it may be that you need to revisit it and make sure, because our goal when we do estate planning is that our clients will have peace of mind and know that things are going to be taken care of the way they want. Okay, so we'll go through a few of the common myths that we hear. So the first one I have here, this may be the most common one that we hear, is that if I have a will, my estate won't have to go through probate. So think about that for a minute. So a will actually has to go through probate. In Oklahoma, and really in any state that would be true. So the word probate actually means to prove. And what you're proving is you're proving the will, if there is a will, and you're proving who the heirs are. So that's what the probate process is designed to do. So there are different types of probate. You can have probate with a will, which is called testate probate, or without a will would be intestate probate. And if we don't have a will, then your estate is going to be divided according to what the Oklahoma statutes say. Okay, and that may not be in line with what you want. So having a will is generally better than not having a will. But most people want to avoid probate if we can. And the reason we want to avoid that is because it's expensive, it's time consuming, and in Oklahoma in particular, our courts supervise that process. So if you need to do things like sell a house in a probate, you can't just do that. You have to get permission from the court. So there are a lot of steps in that process, and that's why it takes a long time, and that's why it's expensive. So there are ways to avoid probate, and we want to do that, but wills do have to go through that probate process. The second one we have is, I don't have enough assets to need an estate plan. So we get those calls sometimes too, or we hear people say that, I don't really own anything, so why do I need an estate plan? Well, there are different estate planning documents that do different things. So it may be if you really don't have any assets, there may be other estate planning documents that would be appropriate for your situation. So even somebody that doesn't have anything would still need estate planning documents, because you would want somebody to have the power to take care of you if you were incapacitated. So if you needed somebody to make your medical decisions for you, for example, if you're incapacitated, it would be important for you to have estate planning documents in place. And when people say this, usually people do have some assets, even if they say they don't. So most people have a bank account and things like that. So there is planning we can do. There are different levels of planning that are appropriate for different situations. Okay, the next one, myth is that my spouse automatically has the right to make my medical decisions. So I hear that sometimes too. People say, well, I'm married, so my spouse can make my medical decisions if I'm incapacitated, so I don't need any documents. Well, under the law, technically, only somebody who's appointed your legal guardian or named in a healthcare document can make those decisions for you. Now, it is true that sometimes medical providers will listen to the spouse and, follow their wishes, but sometimes they won't. And in particular, if it's a very big decision, the medical provider is going to want the legal documentation that gives somebody else the right to make those decisions. So we've seen that happen. For instance, if somebody needs to be moved from a hospital into skilled nursing or a long-term care community, they are going to want a guardianship in place, or if you have a document that gives you the ability to make those decisions, they'll accept that. So the next one says, my children know what I want, and they'll work things out. Okay, so you're laughing, so you know that's not true, right? But we do hear that from people, I trust my kids to do the right thing. Well, it helps if they know what your wishes are, okay? And people get real funny when there's a death in the family, especially when it relates to money, right? And so if you are naming your oldest child as the beneficiary of your life insurance policy and trusting that they will divide things with all of your kids, they don't have to do that, and they probably won't do that, okay? If you name them as the beneficiary, legally that money is theirs, and they don't have to divide it with anybody. So having that planning in place will just be assurance that your wishes are going to be followed no matter what. The next one is, since I'm married, everything will go directly to my spouse. So this could be true. So this one may not be a complete myth. If you have your assets all titled jointly with your spouse, at the death of one spouse, everything may go to the other spouse with no problem, okay? The only problem is if you have an asset that is just in that deceased spouse's name, then that asset may have to go through the probate process. And under Oklahoma law, if you die without a will, like I said earlier, we have to follow the Oklahoma statutes as far as how those assets get divided. And under the Oklahoma statutes, if you're married, not everything goes to the spouse. So that is kind of shocking to some people. You think if you're married, well, everything should go to my spouse. But under our statutes, it actually says it would be divided between the spouse and your children. Or if you don't have children, it could go to the spouse and the person's parents or siblings, which is a really weird result. So there are just some strange things like that in our statutes that a lot of people aren't aware of, and that, again, is why it's important to have some planning in place so that you don't end up with your assets going to somebody you may not want to have it. The next one is I have beneficiaries on all of my assets, so I don't need any planning. So we get that question a lot. Sometimes that works, right? If you have a beneficiary on your bank account, if you do a transfer on death deed for your house, we'll talk about that later. If you have beneficiaries on your retirement account and you pass, those accounts will go to those beneficiaries. The problem happens is if something happens to one of those beneficiaries. So, if you have a beneficiary that passes away before you, then we're back in probate, right? Or let's say you have a beneficiary that's incapacitated, then now that person, in order to receive that inheritance, would have to have a guardianship or something like that in place. So it gets complicated, and beneficiary designations don't always work out. So, having a comprehensive plan is always the best way to go. And then the last one says, I don't need an estate plan because I'm single and I don't have kids. Well, those are the people that definitely need an estate plan, okay? For the reasons that we've said before. You need to name somebody that's going to be able to make your decisions for you if you're not able to. And you want to, for sure, designate who you want to receive your assets if you're not married and you don't have kids. Otherwise, again, under our Oklahoma statutes, it's going to go to what's considered your closest living relatives, and that may not be the people that you want to receive it. You may want to leave your assets to a charity or to, other individuals who have played an important part in your life. So that's something to consider as well. Okay, I'll go to the next one. So here's a list of the documents that we include as part of estate planning. As I mentioned before, there are times where, maybe we would recommend you don't need all of these documents, but this would be a comprehensive estate plan to have all of these documents. So there's a trust, a will, a general durable power of attorney, which is like a financial power of attorney. There's a healthcare power of attorney, advance directive, HIPAA authorization, and then affidavit of disposition of remains. So those are all the documents that would make up your estate plan. So we're going to go through each of those, and I'll explain what all of those documents are for you. Again, you may be familiar with some of this information, so it would be like a review, but if not, hopefully this is helpful for you. So the trust that we're talking about today is called a revocable trust, and that means that it's a trust that you can change. So you can amend that trust, you can make changes to it, and you would be in control of that trust during your lifetime. A trust can avoid probate, and how it avoids probate is the assets would be titled in the name of your trust and not your individual name. So if you're incapacitated, the person you name as your trustee would be able to step in and manage those assets for you without having to be appointed your guardian through the court. So it avoids guardianship and helps during your incapacity. It also provides privacy. So a trust doesn't have to be filed with the court. And generally, I advise my clients not to give their trust out to third parties like their bank or things like that, because it is a revocable trust. You can make changes to it. So you don't want somebody to have an old version of your trust if you do update it. Whereas like a will would have to be filed with the court at your death, and it's all public record. So you can go on OSCN, I don't know if you're familiar with that website, and you can look up probate cases and find those. Even people that are well known in Oklahoma who have died, you can find their probate on OSCN and read all about their assets and different things like that. So it's all public. With a trust, you can have greater control over distributions to heirs. So if you have, let's say, a grandchild that is a minor, and you want them to receive part of your estate, we can include provisions in your trust so that there's some control over how they would get the assets out of your trust. So most people don't want their grandchild having access like when they turn 18, because I don't know about you, but most 18-year-olds are not going to be mature to make a good financial decision. So it allows you to have that control as far as how distributions go to your beneficiaries. It can also provide creditor protection for your beneficiaries. So again, if the assets are held in the trust, then the beneficiaries the assets would not be subject to any claims of creditors, so long as the assets are held in the trust. One of the key things with the trust, in order for it to work, is that the assets actually have to be transferred into the trust. So that means title to your home, your bank account, your cars, all those things needs to be changed into the name of the trust. Okay, so it's a different way of thinking about your assets when you have a trust, because your house is not going to have your name on it, it would have the trust name on it, but you still have control over it. There is less cost and administration at your death because we don't have to file probate. So things can be taken care of outside of court by your trustee. And it can provide a seamless transfer of assets to your children or your beneficiaries. So with a will would only speak at your death, so obviously a will doesn't have any type of claiming for incapacity. So if you only had a will and no other documents and you were incapacitated, a guardianship would be required. And a guardianship is another court process where a petition has to be filed and a person would be appointed as your legal guardian. We also refer to it as a living probate. So there are the similar steps as a probate process, except the person is still living. You also have to report annually to the court in a guardianship, so it's ongoing. At the person's death, if all you have is a will, a probate would be required. Probate takes, I usually tell people, a minimum of 6 months. It can take 6 months to a year is usually what I tell people if it's an uncontested probate. It can definitely take longer than that. We closed a probate this year that had been going on 5 years. So that was, a unique situation, but it definitely can happen. We have to get permission from the court to sell property, there's no privacy, and there's going to be much higher costs. So even in an uncontested probate, I usually tell people to expect it could cost anywhere, from $6,000 to $10,000 to go through that process. And it depends on, different factors. Now, when we do a trust, we still prepare a will for people, okay? That type of will is what we refer to as a pour-over will, P-O-U-R. And that will says, I leave everything to my trust, okay? The purpose of a pour-over will is if you died and there's an asset that you did not get transferred into your trust, then that asset would have to go through probate, but the end result of the probate would be that it would go into the trust and be distributed according to the trust. So it's really a safety net that we do that pour-over will for our clients, so that if there's something that's left out of the trust, it will still be covered. The goal when we do estate planning is that we'll never have to use that will, okay? Obviously the goal is to avoid probate, so, if we're having to use that will, that means something didn't get done, okay? So the goal is we don't want to have to use the will, but we're going to prepare it just in case, because we want to make sure we have all the bases covered. The rest of the documents we refer to as ancillary documents. That's just a legal term that means kind of all the other documents. They are no less important than a trust or a will, and actually maybe more important to some people, because this deals with how you're treated during your lifetime. So there's the general durable power of attorney. So that's a financial power of attorney. So the person that you name as your agent, or attorney in fact is another way to say that, would be able to make your financial decisions for you. So that includes like your financial accounts. They could talk to your utility companies, your cell phone provider, insurance companies, Medicare, Social Security. All those things would be included in a really good comprehensive power of attorney document. The powers in that power of attorney document have to be specific. So you have to specifically say all the things that you want that agent to do. So it's not sufficient enough to say, I just give them all the powers that I would have. So you have to list those powers. One example would be, we recently had a bank, and the power of attorney and the trust that we prepare include banking powers, and it has all kinds of things listed for banking powers. But it didn't have the specific words, safe deposit box. So the bank said, oh no, we can't accept this for this lady's safe deposit box because it doesn't have those specific words in the document. So now all of our documents say safe deposit box, right? Because we have to make sure that our documents are going to work for all the different financial institutions. A power of attorney can be effective immediately, or it could be effective only on your incapacity, and that would be what we call a springing power of attorney. So it springs into effect when you're incapacitated. Most of the time, I recommend to my clients that they have their power of attorney be effective immediately. And so that means that they still have full control over their assets, right? But they're also giving that power to somebody else. And this better be a trusted person. So it could be a child, your spouse, or a very trusted friend. You have to really think carefully about who you're going to choose to put in these roles, because you are giving them a lot of powers, but it's still preferred to go ahead and make that plan rather than leaving it up to a court later on, right? So typically we recommend that it be effective immediately. Financial institutions are more apt to accept a power of attorney if it's effective immediately versus a springing power of attorney. A springing power of attorney is going to require documentation from a doctor. So they want, typically you have to get 2 letters from your doctor saying that the person is incapacitated. So from 2 different medical providers. That is not always an easy task, okay? Doctors want to be doctors. They want to treat people, they want to do surgery. They don't want to write letters that are going to end up in a court potentially. So some doctors are hesitant to provide that information. We also do a healthcare power of attorney. So healthcare power of attorney document deals with all types of health-related decisions. So the person you name in that document would be able to make your medical decisions for you if you're not able to. So this would include like authorizing you to have surgery, getting you pain relief, hiring and firing doctors, making arrangements for home health, hospice, long-term care, all those health-related decisions. The advance directive for healthcare, most people have heard of this document because if you've gone to the doctor or if you've had surgery, they're going to ask you, do you have a living will? Okay? A living will is the advance directive. I don't like that they call it a will because it gets confusing. Then you think they might be talking about your last will and testament. So we, in our office, just call it the advance directive for healthcare. And this document deals with end-of-life decisions and how you want to be treated. And this is a really important document. Some people say, well, do I need a healthcare power of attorney and the advance directive? Yes, because they're two totally different things. The advance directive is very specific to certain end-of-life situations where the healthcare power of attorney would cover other health-related decisions. So on the advance directive, you actually make choices as far as whether you would want to be on life support or whether you would want to have a feeding tube if you're no longer able to swallow. So those are the decisions you're making on that advance directive. We spend a lot of time with our clients going through this document because it's a lot to think about. You also appoint a healthcare proxy on that document, and that would be the person to carry out your wishes. So again, that's important. There's also organ and tissue donation. So if you're an organ donor, on that document you can specify certain things that you want. If you just want it to be for transplantation, you can specify that. So that's also included in that document. We also do a HIPAA authorization. So this would be an authorization for release of your medical records, and I'm sure everybody's heard of HIPAA. Usually when you go to the doctor or hospital, they have you sign a HIPAA release where you're listing people that you want to have access to your medical records or talk to your doctors. So the one that we prepare would be generic for any healthcare provider. It's also effective for up to 2 years after your death. And the reason that it's effective up to 2 years after your death is if you died and your family needed to get your medical records, they would be able to do that without having to have a court order. So that may not happen very often, but it's something we include in there. And we did have a client that was able to use the HIPAA authorization to get her husband's medical records, involved like a medical malpractice issue. So, and then our last document that we include is called an affidavit of disposition of remains. This is a really short one-page document that will say whether you want to be cremated or buried, and then who you want to be in charge of making those final arrangements. So I have some clients that for some reason that decision alone is really difficult. And I always encourage people to, if they haven't made that decision before they come see me, that they need to go ahead and decide that decision, because that is something that can weigh really heavy on your family if you don't, if they don't know what you want. So it's good to put that down on paper so that your family will know, and it makes it really easy for them to carry out your wishes. So my father passed away a few years ago, actually from COVID, and it was shocking. We didn't expect that to happen. But what was even more shocking is we were able to come up to the hospital. It was, COVID was such a weird time. They wouldn't let you go up to the hospital while he was in the hospital. But then when he passed away, we could come up to the hospital to see him. It made no sense. But in that moment, and it looked like a war zone in there. I mean, it was horrible. But in that moment, they came up to me and they said, "What do you want us to do with the body?" And it's shocking for somebody to ask you that when you are dealing with grief and things. But thankfully, we had done his planning, and I knew what he wanted. So it was really easy for me just to answer that question and move on. I didn't have to wonder what I should do. I already knew. So I always encourage people to go ahead and make that decision if you haven't, and make sure that your family knows that too. All right, everybody doing okay? All right. So here are a couple common questions, and like I said, hopefully you've written down some questions so we can go through some other ones. But these are some frequent questions that we get in our office. So we've been talking about a revocable trust. So a lot of people will ask, well, what is an irrevocable trust, and which one do I need? So an irrevocable trust is a trust that cannot be changed. So it's irrevocable. It can't be revoked or changed. Irrevocable trusts are used for very specific purposes. So we use them in our practice sometimes when we do Medicaid planning. Medicaid planning is if you have somebody that's either in a nursing home or going into a nursing home, and we're trying to preserve as much assets as we can for them if they're facing, a long period of long-term care. So you can use an irrevocable trust to do Medicaid planning, but Medicaid has a 5-year look back on any transfers, so that trust has to be established 5 years, before it would be able to help them as far as qualifying for Medicaid. There are irrevocable trusts that can work for asset protection. So people ask a lot about asset protection. Typically, when you're doing an irrevocable trust, in order to get asset protection, you have to give up control over those assets, right? So same thing with Medicaid planning. A Medicaid trust is an asset protection trust. So you are giving up control of those assets to somebody else. So that's why I have a lock on that one, because essentially what you're doing is you are putting those assets in a treasure chest, you're putting a lock on it, and you're closing the lock and giving the key to somebody else, okay? So they don't count for Medicaid because they're no longer your assets, you've given them away. That's how that works. We don't do a lot of irrevocable trusts for that reason. Most people want to be able to control their assets during their lifetime. That would be a whole other class if we wanted to talk about Medicaid planning. The second question is, should I have a transfer on death deed? So transfer on death deeds are a tool that we have in Oklahoma. We had a statute passed not that long ago. So I want to say it was 2009 or 2010, I'm not sure, that permitted transfer on death deeds. So it's still a fairly new statute, and there's not a lot of case law on transfer on death deeds. We have used these in our practice for clients. So basically what you're doing with a transfer on death deed is you're naming a beneficiary for your property. Sometimes they can work well, other times they don't work. So we don't always recommend them. So one thing about a transfer on death deed in Oklahoma is that it has to be executed correctly. So you have to have 2 witnesses and a notary. It has to have very specific language on the deed. The deed form is actually in our statute, so you have to use that deed. If you try and Google it online, you may get a form that is not the Oklahoma form. So you have to have the correct form for that. It has to be witnessed by people that are not related to you by blood or marriage, and it has to be notarized, and then it has to be recorded with the county clerk during your lifetime. So we did a gift class a couple of years ago, I think, and we had somebody there that had a transfer on death deed, but they had not recorded the deed, and so it would not be, if that person passed away, it wouldn't be effective because it had not been recorded. The other requirement with the transfer on death deed is after the person passes away, whoever you named as the beneficiary on the deed has to file an affidavit with the county clerk attaching the death certificate to accept that property. And that has to be done within 9 months. So we've done 2 probates on on cases where there was a transfer on death deed, but the beneficiary failed to file an affidavit in time. So it only works if you meet all of those requirements. If you're married and you already own your house jointly, I don't recommend doing a transfer on death deed on top of that. It's too complicated, and our statutes don't provide a good explanation. I've talked to title attorneys, and they're like, I don't know if it'll work or not. So we don't do those. We don't recommend it. If you're married and you own your house jointly, you've already got a beneficiary on your house. So that's the deal with the transfer on death deed. Another question we get is, how often should I update my trust or estate plan? Yes. She's coming in 5 minutes, which is fine. So we recommend you update your estate plan anytime you have a major life change. So if somebody has passed away, if you've gotten married or divorced or anything like that, you need to revisit your estate plan and make sure that it's still what you want and that you've named the people that you want on there. If there are changes in the law, we also recommend that your estate plan be updated. Sometimes it's hard to know, if there's been a change in the law that would affect your estate plan. So that's why we recommend you work with an attorney to do your estate plan so you can get that reviewed periodically to make sure everything's still up to date. And the last one is, do I need a trust if I'm named beneficiaries? I think we kind of answered that on the other slide. Beneficiary designations can work, but sometimes they don't work if the person passes away, if they're incapacitated, different things like that. So a trust is a good way to have a plan in place no matter what the situation would be. Okay, and then here's a couple of mistakes to avoid, and then we'll have questions. So do-it-yourself estate plans, we don't recommend. Obviously, I'm an attorney telling you that, but I have seen a lot of disasters caused by people doing their own estate plans. Not funding your trust, so funding your trust is getting your assets transferred into the trust. If you don't do that step, then you'll have to have a probate at your death. Choosing the wrong fiduciaries, so if you choose somebody that is not good with money and you name them to be your trustee or executor and they spend all your money going on a trip around the world, then that wasn't the right person to name. So you have to be careful about who you name. Failing to review your estate plan. And then the last one is not communicating your wishes to your loved ones. So, it's best to communicate what your plan is to your family so they're not surprised later on. At a minimum, they need to know that you've done your estate planning so they know they need to look for it. But we do recommend that our clients communicate their wishes and their plans to their loved ones. So this is one of my favorite quotes. Let our advanced worrying become advanced thinking and planning. So that's what this is about, is really getting peace of mind. And that's everything I have to say, but I'm happy to answer questions if we have questions.